A Pennsylvania court finally came to a conclusion on a very important issue involving the 2020 election. We spent a lot of time on this channel talking about it, Act 77, and some of the other modifications that were made in the days, months leading up to the 2020 election between Donald Trump and Joe Biden. Many people saying that a lot of these election modifications were not constitutional. Finally, a Pennsylvania court agrees. Says here that Doug McLinko, you can see this gentleman here, is now facing several people from the Commonwealth of Pennsylvania. Versus as respondents, we've got Veronica de Graffenried. See here, acting secretary of the Commonwealth of Pennsylvania. There's a lawsuit from Doug and others. This is Timothy Zimmerman. We've got Rap Gleam. These are a number of other individuals in Pennsylvania. This here, I believe, is Doug McLinko. And so they are bringing this suit. They're saying that there is a big problem constitutionally with Act 77. This is being heard in front of a panel of 5 judges. We can see the judge who is writing the opinion, Mary Hannah Leavitt. And so we're going to go through this here in a little bit more detail. Doug McLinko, we can see this gentleman, filed an amended petition for review. And so what he's saying is that this Act 77 violated the Constitution. Pennsylvania, of course, has a state constitution. There was an act called Act 77 that established that a qualified elector may vote by mail. So you can just vote by mail. McLinko says, no, you can't do that. The Pennsylvania Constitution requires an elector to present her ballot in person at a designated polling place. It's in the Constitution unless there's an exception. And so they've referenced that right there from Pennsylvania. No excuse mail-in voting cannot be reconciled, according to McLinko, with the Pennsylvania Constitution, saying there is a direct problem facially between Act 77 and the Pennsylvania Constitution. They are at odds with one another, and so you cannot slap Act 77 right on top of it. Respondents, the Commonwealth of Pennsylvania, you can see here, Veronica de Graffenried, she says that Act 77's system of no excuse voting does conform with the Constitution because there's a different provision of the Constitution. Here you can see it's not Section 114, it's Section 4, where it says that ballot by mail, by ballot, or by such other method are allowed under the law. So she's going to hang her hat on this phrase, such other method. She's saying, well, that can include voting by mail. And so she raises some other issues about standing, and we're going to skip over those. She can see, though, once we fast forward right through the opinion, we're going to get down to the analysis section, and Judge Leavitt is going to give us a little bit of guidance on this. She writes, I know there's a contentious dispute about this, but let's go back in time. Since 1838, the Pennsylvania Constitution has required a qualified elector to appear at a polling place in the election district where he resides and on election day. We've got some requirements there. Since 1838, this has been how we've been doing it. This requirement was adopted, quote, thereby to exclude disqualified pretenders and fraudulent voters of all sorts. Right? There are reasons for that. You show up at the right place at the right time. You make sure you're qualified. There's a method you follow. And they're referencing a case called Chase. In 1864, an exception to the place requirement was introduced to the Constitution when we got absentee voting. Its very name, quote, absentee, relates back to Section 1, saying that electors vote in person at the polling place. Absentee says, well, got to go back to that first requirement about appearing at the polling place. Judge Leavitt says, our Supreme Court has specifically held that the phrase, quote, offer to vote requires the physical presence of the elector, whose ballot cannot be sent by mail, nor can it be cast outside of all Pennsylvania election districts and certified where the voter has domicile, referencing Chase. It says there must be constitutionally provided exceptions before the offer to vote requirement can be waived. Our Supreme Court has further directed that before legislation can be placed on the books, an amendment to the Constitution must be adopted. This is our fundamental law, saying that you can't just slap on Act 77 on top of the Constitution if they are at odds with one another. This moves on. She says, in dismissing the construction of that article of our Constitution, Veronica, the acting secretary, places all emphasis on another section in Section 4, saying that that elections can be operated by ballot or by such other method as prescribed by law. And she's using this phrase right here, right? Other such method, saying, no, 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 hold on a minute. I can do vote by mail without any excuse because the Constitution says I can. It's right here in this section, section 4, which states by other such method. And so she's saying that this opens the door for her to just drive a truck through it. She argues she has nearly unbounded discretion to enact legislation except where specifically prohibited, so that the door is open and she can do whatever she wants with it unless the law says she can't. And she says because there is no express prohibition in our Constitution against legislation about mail-in voting, it can be allowed. And Judge Leavitt is writing, no, this logic was rejected in that prior case called Chase. The acting secretary does not grapple with the holdings in Chase, which she says is not in line with the, quote, modern way constitutions are construed. And so this acting secretary is now saying that she's just sort of not going to even follow the holding of Chase because it's not in line with the way modern constitutions are construed. Judge writes, she's undeterred by the inconvenient truth that the provision authorizing such other methods was a part of the Pennsylvania Constitution when Lancaster City was decided. Okay, they already took that into consideration in the prior case. Says, Madam, to read Section 4 as an authorization for no excuse mail-in voting is wrong, and it's wrong for 3 reasons. Number 1, no excuse mail-in voting uses a paper ballot and not, quote, some other method, which is defined in the law. So it's articulated that a paper ballot is appropriate under some other provision, and so we can't put that in the other method bucket because it's defined elsewhere in the law. It says, second, this reading unhooks Section 4 from the remainder of the article, as well as his historical underpinnings. It ignores the in-person place requirement that was made part of our fundamental law in 1838. Third, it also renders surplusage, which means this is just unnecessary language. The acting secretary's interpretation of such other method means the legislature always had the authority to extend absentee voting in any circumstances under whatever conditions she wants. And says that there must be a constitutional, and she says, the judge writes, that is dead wrong in holding. Says that there must, in fact, be a constitutional amendment to authorize that expansion. You can't just slap on Act 77 right on top of this. And so Judge Leavitt writes, in conclusion, says, in Chase, the Supreme Court rejected Mr. Miller's argument before the court because the Pennsylvania Constitution did not contain a clause that prohibits the legislature from passing a law authorizing soldiers to vote at their respective camps. Here we get the Supreme Court explaining, saying that they acknowledge the hardship of depriving a meritorious class of voters the right of voting. The Supreme Court explained that, quote, our business is to expound the Constitution and laws of the country as we find them written. We have no bounties to grant to soldiers or anybody else. It further explained that while soldiers fight for the Constitution, they do not expect judges to sap and mine it by judicial constructions, okay? Do not alter the language, sap the language of the written text, and maneuver it to whatever outcome you want, okay? Basically, what this woman was saying was not a modern reading of the Constitution. Judge Leavitt writes, the court gave a natural and obvious reading to the place element to suffrage set in the Constitution. And we reject the strained construction of the article by the acting secretary to avoid the clear directive of our Supreme Court. Just because she may think it's not a modern interpretation doesn't mean that she can just circumvent it. No excuse, the judge writes, no excuse mail-in voting makes the exercise of the franchise more convenient and has been used 4 times in the history of Pennsylvania. Approximately 1.38 million voters have expressed their interest in voting by mail permanently. If presented to the people, a constitutional amendment to end the Article 1 requirement of in-person voting is likely to be adopted. But a constitutional amendment must be presented to the people and adopted into our fundamental law before legislation authorizing no excuse mail-in voting can be placed upon our books, referencing the case Lancaster City, saying, you may very well be able to pass this, But you've got to do it the right way. It's got to be done through a constitutional amendment because it says in the Constitution that there is a place requirement. Act 77 can't undo something that has been constitutionally anchored without a constitutional redaction, removal. Judge writes, for these reasons, we grant summary relief to Miklenko, and we declare that Act 77 violates the Pennsylvania Constitution, unconstitutional. We deny the acting secretary's application for summary relief on the grounds proffered therein. Let's take a look at the order, because all this essentially is a declaration, and we're going to see what happens next. But this is from the same case. It says, and now at the bottom, the 28th day, so ordered, Miklenko and others, their motion for summary relief is, you can see, granted. The application for summary relief filed by Veronica de Graffenried is denied. And additionally, all of the other objections, of course, are dismissed as moot because they lost. So Veronica, the Democratic National Committee, and the DNC in general all lose the issue. But you'll notice here, like, not much in terms of any other orders. This is the order from the court, and it's not saying that the results are reversed or anything like that, right? That's not what it's saying at all. It's just giving a declaratory position on Act 77, saying it is unconstitutional. Now, we know that the Democrats have already appealed this, and so what that does is it stops this ruling from going into effect. It says Pennsylvania, from the New York Times, filed an appeal to its Supreme Court on Friday afternoon, triggering an automatic stay that keeps the law in place during the appeal process. And so we'll see how long that takes, but there's an election coming up rather quickly. Josh Shapiro, the Democratic Pennsylvania Attorney General, also running for governor, said this decision is faulty. Said the opinion is based on twisted logic and faulty reasoning and is wrong on the law, said Mr. Shapiro. So we'll see where this goes. Now, there's an election coming up pretty soon, near the end of the year. Pretty important one, too, for both parties in power. And so we're going to see what Pennsylvania does about this, because Act 77 did change a bunch of the election rules. It sort of modified, as we see here in this opinion, what the original law was. And there's a question about whether that was allowed or not. And so if it is allowed to stay in effect, all of those same election rules that we saw leading up to 2020 when Act 77 was in effect will also be in effect. But if the Pennsylvania Supreme Court comes out and finds and agrees with the lower level court that this was in fact unconstitutional, well, Pennsylvania may not have that mail-in voting anymore. And some of those alterations from Act 77 will be rolled back right before November. So we'll see. We'll continue to follow it along. We spent a lot of time talking about all of the election litigation leading up until 2020. We're going to continue to do it again because we know what is at stake. And I hope you join us in that journey. Definitely hit the subscribe button. We have a live show that we do weekdays. I would love it if you joined us for that, because I look forward to seeing you on the next one.